So I hear a rumor through Ms. Persfield that y'all, in the break, have been able to talk about everything that was still outstanding and either have come to agreement or have significantly narrowed things, and whatever is left is going to be short enough to deal with after court on Tuesday. Is that right?
Yes, Your Honor. We're going to, the state intends to give the pared down version of the March 2022 folder over the weekend, and then we'll be able to discuss if there's any objections to it, and then be prepared to argue it on Tuesday.
Write myself notes. Okay, and y'all, the defense will come up with a proposed instruction for the text from Mr. Stillwell to his girlfriend about drinks being dead.
Lucci, you're on.
Lucci, whatever, sorry.
No, it's okay. Thank you.
My bad, Lucci.
We'll take care of that, Your Honor.
Okay. The one before that, that was the song lyrics from Mr. Stillwell. First of all, so your proposed is the general, sometimes evidence is admitted against some parties and not others. When this happens, the evidence may be considered by you, the jury, only as to the party against whom it is offered and not against any other defendant or for any other purpose. That's fine. That's just kind of the general law. During the testimony of the next witness, you're going to hear about statements. I definitely do not want to call them statements. So maybe lyrics, what? Sung, rapped, by, just lyrics, by.
Lyrics uttered, spoken, rapped.
Words spoken with a beat.
I would rather not. Words spoken with a beat. Lyrics.
Song lyrics of defendant Stillwell, by defendant Stillwell.
The state is that the state asserts is defendant Stillwell. I don't know if we should instruct them that it was definitively. I'll say that I am not, as part of my defense, going to be claiming it's not, but out of abundance of caution, maybe.
Okay, how about just certain song lyrics? You are to consider those lyrics Did you copy, yeah, Mr. Shard on this also? You did, okay. Can y'all work on this one as well, please?
Yes, Your Honor.
And then I am not sure that, the reason I said it's maybe overbroad is that you're saying that those can't be considered in any way in determining the guilt or innocence of Mr. Kendrick with respect to any charges.
You'd like to leave the RICO count out
I
of that?
just don't think that that's legally accurate. Yeah.
Okay.
So.
We'll try to more narrowly tailor that, Your Honor.
Okay. Thank you. And I know we had talked previously, we thought we were getting to the Ryan conviction first, so I talked specifically about the language for when Mr. Ryan's conviction came in, but now that conviction won't come in, but we still have the possibility of a guilty plea conviction for Mr. Kendrick being admitted, right?
Yes, ma'am.
Okay, so I think I shared with y'all that language. It was kind of Kendrick on the top and a version of it on the bottom for Ryan. But anyway, I will if I haven't yet. But I would think it would be, and I don't know whether I could either say a guilty plea conviction of Mr. Kendrick or a guilty plea conviction of Mr. Kendrick for whatever it was for, will be admitted for your consideration and may be considered by you only against Mr. Kendrick and only as to counts 1 and 63, which is the possession of a firearm by a convicted felon. You may not use this conviction in your consideration or deliberations against any other defendant in this case. Now that we only have one, I could say that, or I could just say against Mr. Stillwell. Any other defendant in this case. Okay. It is not evidence of anything against the other defendant. Each defendant has a right to have his guilt or innocence determined solely on the basis of the evidence presented against him, not by what may have happened with regard to a criminal prosecution of someone else. I'm going to have to look back at, what is the conviction for? What is the guilty plea conviction for?
It's possession. No, it's 15 SC, booklet 14011.
John, what I was going to do before I left today, if I had the opportunity, I was going to go through and
That'd be great.
get all those for Mr. Winfrey, for my client.
That'd be great.
For Mr. Kendrick and Mr. Nichols.
Let me ask this. Is it an overt act? Whatever he pled guilty to.
They are overt acts, and that's essentially the problem is their admissions. I mean, at this point, I would argue that Mr. Nichols' guilty plea should really not be in evidence because it doesn't have any probative value to anyone else's case that's sitting here at this point. And same with Mr. Winfrey for that. And
If they're overt acts, though, and they're alleged to be in furtherance of the RICO conspiracy, then you're right. The convictions themselves are not. But what I'm trying to figure out, and if like, for instance, Mr. Kendrick's, whatever he pled guilty to, is also an overt act, could y'all?
It is. It's for the October 1st, 2015 incident.
Which overt act?
It is overt act number
Was it 58 or 59?
58. Well, no, 58 is the gun charge.
58 is the gun. 59 is the criminal street gang activity.
Overt act or count?
Overt act.
Overt act.
Okay. Overt act 58?
56, well, all 56 and 59 is the same incident, so it would be really overt act.
What did he plead guilty to? 56 through 59?
Yes.
Okay, I think I'll just pull up his guilty plea.
He pled guilty to the entire indictment, which was a conspiracy to commit murder, theft, possession of a firearm, and participation in criminal street gang activity.
And did that participation in criminal street gang activity, was that specific? I don't think he did.
I don't think that's accurate.
I
Can I
don't think
take a
so
look
either.
at that?
I don't think he pled guilty to the gang count at all.
Yes, you pled guilty to conspiracy to commit a crime, participation in criminal street
To
gang.
commit a crime or to commit murder? We've got, I mean, thank you. We actually have, I'm sure, somewhere the guilty plea. I'll make sure that it is not something you didn't plead guilty to. So many folders in this case. Conspiracy to commit a crime, 1648.
Aggravated assault. It was conspiracy to commit a crime, which was aggravated assault, which that's what's represented in count 1 of that indictment. Participation in criminal street gang activity. Possession of a firearm or knife in the commission of a felony. Theft by receiving stolen property. And BGCSA. I'm gonna make sure that he's trying to all counts. He's one prison. He's all counts. He's 1 through 11. So there's, let's see, 2 counts of BGCSA, another fleeing and attempting to elude while driving. He pled guilty to the entire indictment. All 11 counts.
Okay, y'all have it listed. Y'all have Overt Act 56 as him having committed the offense of conspiracy to commit murder, which I realize that maybe y'all could arguably prove that, but that's certainly not what he pled guilty to. So, death by receiving, possession of a firearm. Where's the gang count? Okay, and the gang count that he pled to, I just wanted to see if it specified which gang, and it does not. So, and your 59 is specifically YSL, but that's not what he pled guilty to either. Okay, but anyway, so there's obviously evidence that came in aside from his guilty plea, which hasn't come in yet, but presumably will come in. And given that it's alleged to be an act in furtherance of the RICO conspiracy, the conviction can't come in against anybody other than Mr. Kendrick. But I was going to, and I hadn't sorted it yet for Mr. Kendrick, but I know for Mr. Ryan, you know, y'all were presenting evidence of the murder. And you have presented some evidence aside from the guilty plea to this attempted whatever, conspiracy to commit aggravated assault and or murder. And so I was going to say something like, to the extent the state offers evidence aside from Mr. Kendrick's guilty plea conviction to attempt to establish count 1, any other such evidence aside from Mr. Kendrick's guilty plea may be considered against each defendant, because that's true. Again, as to count 1, yeah, okay. So I'll be happy to make some adjustments so that this reads like what I just said and send that out to y'all for any comment or correction or improvement that y'all might want to suggest. And then I think that'll get us to the end of what we need to do today on the record. And then y'all are certainly welcome to stay. We're not at 5 o'clock yet. We're just almost to 4 o'clock. to find the evidence and then to organize the evidence, agree upon the exhibits that have already been admitted, whatever you might want to do. That's ultimately going to need to be done at some point.
Can I was going to request a report from council if I took the evidence from this room over the weekend, or
I don't think we can do that. That has to stay, whatever's been admitted has to stay with the court reporter. Right?
Well, we're holding some of that.
Oh, well, right, like guns and drugs and things, y'all still have possession of. Okay, so, I mean, I don't mind if everybody wants to come to agreement, I don't mind. Are you talking about just to take it home and organize it?
that's all I want, or
I'd really rather y'all look at it together.
Yeah, and I don't have, I think it's probably unwise, and it's nothing personal against Mr. Abate, of course, but I was just being selfishly thinking about closing, and we need to figure out where different things are. And then, of course,
I would highly recommend that y'all stick around and try to get the evidence that's been admitted already organized together.
okay.
And I know that,
Can we take it to the jury room to just? Oh, that's right, because they got their stuff in there right now. Can we take it to that side room, just so we can have something to spread it out on?
as long as Ms. Weaver ends up with custody of it again when y'all finish, and as long as y'all are all together with it. And I don't mistrust anybody. It's just not a good practice to. Yes, you could also do it here in the courtroom. And this is just a lawyer exercise anyway, right? So we're done for the day. Y'all don't need me. You don't need your clients. Is this just y'all getting organized? Okay.
Your Honor, may I just put one brief thing where I talked with defense counsel for the ankle monitor company.
Oh, thank you, Mr. Atkins.
You're welcome, Mr. Sharp.
Yes, what's the next?
No, Your Honor, on witness number 19, which is listed as Charles Floto Ankle Monitor Company, the state was going to be using Doug Bailey for that same position as records custodian. And I talked with defense counsel about that. So I didn't want the court to be caught off guard with the name that's not on this list that's replacing this records custodian.
Okay.
So let me just put this on the record, Your Honor. My client was wearing an ankle monitor at the
Right.
time of all this happening. In my view, and this has already been litigated, but I just want to put on the record, in my view, we are not disputing that Mr. Stillwell is at the BP on video, so I don't think his whereabouts, to the extent that an ankle monitor clarifies anything, it's not really made any more clear by the ankle monitor. It's not really a dispute
Are
in
y'all
this
going to
case.
stipulate that he was at the BP?
before and after.
So the state, I believe, wants to bring out where he was through his ankle monitor. My argument was,
Getting the windows tinted.
Or the car clean.
Is it going to show that? Oh, that would be interesting.
well, so I have objected on the record for
Because
the,
it's going to show that
that
he was
he's,
an ankle monitor?
he had an ankle monitor, and I objected under 403.
All right, but don't we know anyway that he got arrested on, oh, wait.
I don't think
no,
he was
that
on the ankle monitor for any of these other issues.
Okay.
There was an
so-
incident in Cobb County.
Okay, y'all already litigated it then?
It did. We did, and I just wanted to put on the record. But I think probably if we're just going to say he had an ankle monitor on, but just leave it at that. So
Are we just going to leave it at that? Okay.
Just very quickly, Mr. Shard and I were just discussing, Investigative Viverito has familiarity with Mr. Stillwell, as well as others, Mr. Garlington, through her time working with the probation department, Mr. Copeland, and just figuring out how to deal with how she knew them. We're going to probably use some language such that she worked for court services, and that's how she knew them, because he doesn't want us to mention probation. But we just wanted to bring that to the court's attention.
How do you feel about that, Mr. Shaw?
Well, I prefer court services. I mean, I don't think that's, I don't want to lie to the jury, but I think that is accurate, but not specific in a way that would prejudice my client.
Okay.
Or the court system.
I mean, court services sounds better than court supervision or what you just said, whatever you said. I don't
Court
remember.
services is good.
I mean, to me it does.
To me as
If
well.
y'all, whatever y'all want to agree to, but
That's fine.
all right. So y'all will stay here with the evidence and sort through it. Mr. Kendrick and Mr. Stillwell, y'all can go. We'll see y'all Tuesday. Hopefully you got some sleep over the weekend. Okay. All right. We are adjourned.